Welcome, everyone. We're going to get started. I appreciate everyone's patience with the logging in and logging off. Technology is great. Once again, I know this is repetitive for some of you, but there's many attendees who this is the first session they are attending. So that's why this information is being repeated. Welcome to Lumsden and McCormick's first virtual annual Exempt Organizations Conference. My name is Maria Gambacorda, and I'll serve as the host for the webinar today. I'm going to run through a few quick housekeeping items. This recording will be available as well as the slide deck. You can check back on Monday. We should have all this information up on our website in the news section by then. We'll also be sharing the link with everyone via email on Monday as well. Chat and Q&A are both enabled. If you have any comments, please use the chat for those, and questions, we'll take questions throughout, and Sarah Dayton, our moderator, will manage the questions on behalf of the speakers. As many of you know, we are offering CPE credits, so therefore all polling and survey questions should be answered. There will be 4 polling questions during the presentation. You'll be prompted for each and we'll share the results. At the end of the webinar, there is a very short survey that will launch automatically. We ask that you please complete that. And again, all of these are required for CPE credit. For those needing the CPE certificate, I will be emailing all of you prior to Monday, December 21st. I'll put my email in the chat in a minute if any of you have any questions on CPE credits. Like I mentioned, the slide deck, a link will be provided by Monday. So I am going to turn this over now to Sarah Dayton.
Thanks, Maria. Good morning again, everyone. Glad you're able to join us. Hopefully most of you were able to attend our previous session, which focused on collective bargaining during COVID and was presented by Kim Georger. Kim is going to serve as a resource to Lisa during this session on employment law. Lisa Coppola has owned 3 Buffalo area law firms in her 30-year career. She and her team take their clients' challenges to heart, whether they're starting a new business, taking their existing operations to a new direction, or facing a claim. Her law firm is the workplace trainer of choice about New York's sexual harassment prevention laws. The Coppola firm is a certified woman-owned business qualified in New York State. Kim Georger is a labor and employment law attorney who has represented employers, employees, and labor unions. Having worked on both sides of labor-related issues, Kim has a unique perspective on employer-employee relations. Kim currently works as a labor relations specialist for NYSET, where she handles collective bargaining and various contract enforcement issues for public and private sector unions. Thank you both again for agreeing to join us for 2 sessions. And Lisa, I'll turn it to you.
Terrific. Thanks, Sarah. And good morning to everybody here. Kim said in the last session, and I want to emphasize this, labor and employment law is on a parallel universe these days because of COVID. There have been so many changes, so many new laws, so many modifications of practices across not only our state, New York, but across the country. And why is that important? Well, 1, because our heads are spinning, but 2, because particularly labor and employment law, unlike lots of other areas of the law, it's governed by both state and federal law. So we have to, as lawyers, as HR professionals, as executive directors, we have to keep our eye on both areas, right? Both the folks in Washington, D.C., but also the folks in Albany. And depending on where you might be in this state, particularly if you're in the New York City area, then you got to worry about local ordinances as well. These days around COVID, we're seeing, as I said, lots of new laws. I have a list of them here. We're going to go through them rather quickly this morning. Rest assured, as Maria said, you'll have this slide deck with information. And if I can figure out the technology, I also have a 1-pager that I'm going to share with our friends at Lumsden and McCormick that they can share with you as well, that will talk about the really important points of all of these 3 statutes or laws we're going to talk about this morning. So first poll question, are you attending this session to earn CPE credits? Yes or no? I know I can't answer the question. I need CLE credits. Anybody? Bueller? Awesome.
We'll keep this up just for another few seconds. Thanks, everyone.
No worries.
You can go ahead, Lisa. We're all set.
Okay, great. So we're talking first about a law called FFCRA, the Families First Coronavirus Response Act. This was passed in March, like right after everybody finally got their brains around COVID in response to this pandemic. It provides leaves, and really we're talking about, right, how do you run, whether you have a nonprofit, a school district, a local government office, or a for-profit business like my law firm that I run, or my landscaping company that I have an ownership interest in. How do we run our businesses, for crying out loud, during a pandemic? And we all know from Kim's perspective that we need to be humane as well as being business people. And some of these laws are designed to help us be humane. FFCRA is a leave law that focuses both on illness and on child care. And that's what we need to know about it. We all know about FMLA, right? That's the Family Medical Leave Act. It's a federal law. It applies to businesses that have 50 or more employees within a 75-mile radius and allows employees to take up to 12 weeks off unpaid but job protected leave due to a series of circumstances, illness of a family member, military leave, things like that, in a 52-week period. This FFCRA expands that and provides dollars for it. So when does an employee qualify to get FFCRA leave? First criteria, if they're subject to a quarantine or isolation order, right? And that's something a local Department of Health would issue when somebody typically has symptoms and goes to the doctor or goes to get tested. That's the first criteria. If you meet that criteria as an employee, generally speaking, you're going to be entitled to this leave. What's another way you're entitled to the leave? Your provider, your physician, your nurse practitioner says you should self-quarantine. Then you're entitled to this leave. What's a third way you're entitled to the leave as an employee, right? And we as employers better know these things, right? Or our HR departments better know them. If you have symptoms and you're seeking a diagnosis, that's the third way you get this federal FFCRA leave. You also get it if you're caring for somebody who's either subject to a quarantine or isolation order, or whose provider said they really ought to self-isolate or self-quarantine. And then the fifth way you get it is if you have a kiddo who's home from school or home from daycare and your regular care circumstances and situations just aren't available. And I will tell you, they're serious about this. So the law was passed in March. It became effective like April Fool's Day. It's now been effective since April. So roughly speaking, right, 6, 8, 9 months. For the first little while, the Federal Department of Labor said, like, if employers are trying to do the right thing, but kind of maybe mess up, we're going to look the other way. They gave them a little bit of time to kind of figure this all out, work with lawyers like Kim and me to figure it out, work with their HR professionals. But now the Federal Department of Labor is serious about employers being required to give this. They just slammed a Georgia business. In fact, I just got this notice this morning, so I printed it out and read it real fast so I could share it with you folks. Slammed a Georgia business for refusing to give child care leave to one of the employees who asked for it under FFCRA. So before we go forward on this, now we know what the circumstances or criteria are. Let's do another poll question. Is your mask of choice paper, fabric, and the more colorful, the better? Or, dear God, I don't care anymore? Go right ahead. Answer our question.
We'll give it another few seconds, everyone. Thank you.
I'm dying to know, Maria, the answer to this, right? We're kind of, between fabric and just trying to survive another day during the pandemic. Okay, now we're going to talk about the employer piece, really. And as I said in the beginning, this is how do I run my school district? How do I run my nonprofit? How do I run my business around COVID? I'm trying to be a good person. And from a business and employee perspective, I'm trying to make sure morale remains as high as possible. But I have services to provide. I have a business to run. What do I do? First of all, private employers, all private employers, including not-for-profits, are covered by the FFCRA. You don't have a choice. One little tiny caveat I'll tell you about in a second. Public employers, generally speaking, are covered by the FFCRA. There's a slice of federal workers who are not, but I suspect virtually everybody on this conference today is covered by it. Here's the caveat I told you about. The less than 50 employees loophole isn't going to apply to any of you school district folks, sorry, and certainly not large nonprofits or large businesses, but smaller businesses, there's this loophole or exception where you as the employer can say, and this relates only to the childcare leave part, by the way, if they're sick, listen, we want them to stay home. We don't want them coming into our workplace, infecting everybody else, having claims that it might be a workers' comp illness, or worst case scenario, a third party claim. You had people in your business and I came in and I got COVID from you, I'm going to sue you. We're already seeing those lawsuits around the country. So here's the loophole for child care leave. If you as the business owner or manager can attest that giving this person the time off will jeopardize your business, including a nonprofit, as a going concern, you can accept yourself out of the mandates of this law. There's certain other exceptions having to do with healthcare providers as well, but I thought this is the one that might relate to the folks on this conference. Here's the rub. Can you really say when that first person comes to you, I need time off, my kiddo's daycare has been closed down, or remote learning, right? I was just like in between these sessions texting with my senior at Amherst High School because their Google Classroom was down this morning and reminding her that I just got a text saying it's back up, so she better get online, right? The first employee who needs to take the time off, can you really attest honestly, truthfully, raise your right hand, that this will jeopardize your business as a going concern? My guess is no. Second person who asks for it, third person, fourth person. We have a lot of employees who have children who are of a school aged, right? What if you got a 20 employee not-for-profit, for example, and you get to your fifth or sixth or seventh person who wants the time off under this FFCRA federal law? Are you then saying, honest to goodness, this is going to jeopardize the going concern of my business? You probably can say it at that point. I'm not giving you legal advice. Everyone understands that. But when you get to a critical mass of people not there, how does the work get done, right? And so the question for you all as folks who run either for-profit, not-for-profit businesses that might be fewer than 50 employees is, what if I'm saying that too? We'll go back to Kim's example from the first session. And for those of you who weren't on it, 42-year-old woman who needs time off, can't work at home, can't work remotely, but needs time off because her kiddo's doing remote learning. Well, if you then say, this will jeopardize my business as a going concern, my nonprofit is a going concern, you can't take the time off. you may be applying that exception for the first time for a woman who has a child and who is over 40 years old. And that is somebody who is in a protected class. And this opens up all sorts of employment related risks to businesses that are contemplating accepting themselves out of this leave statute. Again, I can't give you legal advice in this 50-minute conference session, but I can tell you to notice those things, to be thinking about those things when you're making these decisions, because there may be unintended consequences that you haven't immediately thought of. And so talk to your human resources professionals for sure. Make sure you talk to your legal counsel to get some good advice to cover you. Okay.
Lisa?
Yep.
We have a question, and maybe this goes under the, you would need to check with your attorney for more. So I'll ask it. You can say what you can or can't.
Yep.
This person has an employee that took PFL for the birth of a child earlier this year. Now they have an employee working near that employee that has COVID. The daycare will not accept their child because of this. Would they be able to get PFL again for this daycare issue now? They also used all COVID sick time. Would they need to use PTO?
That is a brilliant question. I love that question. Generally speaking, when you use up your PFL, and that's paid family leave, that's different from paid sick leave, but both are under New York law, you don't get it again in the same year. And this example from Joe, thank you, Joe, is the employee used all their COVID sick time as well. So if they're out of COVID sick time, and my guess is they used it under the federal statute, FFCRA, because that's the paid one. So everybody wants that one, and used their PFL. Right now, they're out of time. And unless Kim disagrees with me, they should not be entitled to more leave unless you want to be incredibly benevolent and give it to them. They may, can't really tell, they may, depending on the size of your entity, might be entitled to FMLA potentially. So that's something to look at. That would be unpaid leave, however. Otherwise, they will get potentially more PFL as long as it's within 1 year of the birth of the child, starting January 1, potentially. So they've got a couple of options, but I think your instinct saying they're going to have to start burning their PTO is probably right on target. That said, Joe, talk to your legal counsel, because there may be factors that, we just can't figure out in a really short Q&A during the conference. But your instincts, I think, Joe, are right on target. You burn through this stuff, it's done for now, right? For this calendar year. So let's talk about, Joe said his employee used all their COVID related sick leave, right? This is the time off that employee got. Typically they get paid 80 hours, which in a somewhat typical workplace is 2 full weeks of sick leave. And then you get 12 weeks for this expanded FMLA under the FFCRA. Usually what employees do, in my experience since, April, right, is that they take the 12 weeks, the first 2 weeks are paid under sick leave, and then the 10 weeks are paid under the FFCRA expanded FMLA. So that's the amount of time folks are getting. This is the compensation. Again, this is sort of granular. You don't have to write this stuff down. You'll see it when the slides are available, and hopefully the one-pager is available to you. There are some limitations with our lower wage earners. They typically don't hit these limitations, but our higher wage earners are exempt. The C-suite folks, and they have kids who are youngsters too, who are out of work or out of school rather, that might create the need to be out of work due to COVID. Some of these limitations may come into play. But here's the great news, right? And Lord knows I'm not, I'm not a CPA. I went to law school because I don't like the numbers, which is why I call my friends at Lumsden when I need assistance. But know that under this federal statute that deals with COVID leave, every business that's paying an employee while they're out gets a withholding tax credit dollar for dollar. Do I know how that happens? Nope, because I'm a lawyer, not an accountant. But I know it does happen. And I know that it's really important to get your employees to certify, and hopefully by now, several months into the situation, you're doing this if it's happened. You need to get them to certify on paper in a signed certification the reason for their being out. Why? Because I'm told the IRS might look at this later on and make sure you have justifiable documentation for getting that withholding tax credit. How do you show that? You show that by your employee providing you the documentation. My child's school, I'm going to just, make it up because it's where I live. The Amherst Public School District is on hybrid, and my kiddo couldn't go to school 2 days of the week, or now, all 5 days of the week. And here's the email from Superintendent Piniella telling us that schools are now closed. That's what you sort of staple to the back of that certification from your employee, right? And you want to have that because you may need to justify it in the future.
Hey, Lisa?
Yep.
There was a question in the chat that I took a look at, and I'm pretty sure it's referring to the paid family leave, and they want to know if they have an existing CBA that was negotiated in good faith prior to the implementation of this law, must they reopen it?
Well, that's a question for you, my friend.
So if you're a public sector employer, the use of paid family leave, the applicability of that law to your workforce, it's negotiable, and you do not have to reopen your contract to negotiate that. And when your contract expires, and your employee organization makes demands about this law, you can say no. No is, don't tell anybody I told you this, but no is a reasonable answer in a collective bargaining environment. We have also been told that with the excessive amount of vacation time, they are not at a loss for time off, and it also is covered by this. Thoughts? I don't know about vacation and paid family leave. I think that they're two very separate things. So if the thought is they have plenty of vacation, they don't need to take this paid family leave or have access to it. As an employer, you certainly could take that position.
Okay, let's just talk for a moment about some practice tips. This is a slide just about the withholding tax and the documentation. I want to give you some practice tips, some things that you can put in place immediately. First of all, for FFCRA leave, you cannot mandate that they tell you all of the details of their health situation immediately. You can mandate that they do tell you, but you can't mandate it immediately, because the thinking is if it's COVID, they've got to focus on their health and not be worried about giving documentation to their employer. This is going to be really different when we get to paid sick leave in New York State in about 15 minutes. Second, you must have the school name or the daycare center name in the evidence. I said that already. It bears repeating. Have that information in your documentation. During FFCRA leave, you are mandated to continue benefits as per usual, health insurance. So if it's a 75-25 split or something like that, you need to continue that, and the employee continues to be liable to provide his or her contribution to those premiums. And then last, under the child care leave part of FFCRA, employees are allowed to use this intermittently. The HR people on the line, I'm sure, are rolling their eyes because intermittent FMLA drives everyone insane. They're allowed to if you say okay as the employer. So it's not required that you say okay, but it's permitted. So what's going to happen? Goodness if I know. This law sunsets on December 31st, 4 weeks from today. It goes away. I wanted to have a question. Will this be revived, right? Because we all thought, and I'm pretty sure those brilliant folks in DC thought COVID would be over by now, right? And that's why this law sunsets at the end of the year. Are they going to revive it? We don't know the answer. We hear there's some bipartisan efforts being made at COVID relief bills for businesses, but your guess is as good as mine, friends. DC is not the place it used to be. So it'll be interesting to see, right? Might it be revived under this administration before January 20th? Or might it be revived in the next administration that begins at noon on January 20th? It's anyone's guess. Here's our poll question. Have you had an employee refuse to come to work fearful of the pandemic?
Sorry about that, everyone. My computer froze. Here we go.
I'd love to see the answer on this, Maria, if we get it. Have you had employees who are just plain scared, right? I've got anxiety over COVID. I don't want to come to work because there's other people there. Look at this. We're about half and half. So here's a practice tip. Generally speaking, fear is not a justification for taking FFCRA or any other kind of leave because of COVID, unless there is documented emotional/mental health concerns with the employee pre-COVID. Stated more plainly, right? You have an employee who has anxiety concerns, anxiety diagnosis, and that anxiety has been further triggered by COVID. That employee may very well be entitled to the leave. Now, we all know mental health information is so sacrosanct, right? It's so private. You might not know about it at the time COVID started. So this is an area where you want to have guidance if this is what happens to you in your entity, where you have some guidance from your legal counsel. So that's the federal COVID related leave. Again, are we breathing a sigh of relief because it's going to be over in 4 weeks? I'm not sure I feel comfortable breathing a sigh of relief, but as of this moment, it is over and done with at the end of the year. Let's keep our eyes on that to see if it gets revived, as I said. Then there's this other COVID related sick leave that the New York State legislature passed and the governor signed in March. It's called New York, as you can see in the slide, New York COVID sick leave, right? For New York COVID sick leave, there isn't an end in sight, meaning there isn't a sunset. There's not a this law will end on a particular date. It's also not as rich in terms of the benefits it provides, and there's no tax benefit to the employer for giving this sort of leave. Again, another dense slide that I'm not going to talk through, but understand that depending on the size of the business, and by business, just so everybody knows, I'm talking about nonprofits as well, the size of the business and the net revenue of the business will determine how many days off and whether those days off are paid or unpaid under this particular New York State statute, right? And so this is, 10 or fewer employees, net revenue or net income under $1 million or $1 million plus. That depends on whether the 5 days are paid or unpaid. Then when you go from 11 to 99 employees, 5 days paid for this. And 100 plus, they're getting 14 days paid. I didn't have a slide about this. Let me say 500 plus employees under this New York law, they're entitled to this leave. The federal law I talked about, FFCRA, 500 plus employee businesses are not covered by that law. The big guys are not covered. So understand that when I talked about the FFCRA, that universe is between 1 employee and 499 employees. What's something that's very relevant about this New York leave, even though it's for a pretty short time, it's job protected, same as FFCRA, meaning same as FMLA that many of you are familiar with. You have to make sure that job is available to come back to when the employee is ready to come back to work. I love the naughty list. It's sort of my favorite thing about COVID. We all know New York State has this naughty travel list, right? That now basically is almost everywhere, other than, right, our state. If the person, the employee, has traveled to one of these do not go to places, they are not entitled to take this New York State COVID sick leave. They're accepted from it, right? They're also not entitled to take this New York State sick leave if they're able to work from home. And now, you know, lots of us are learning for the first time ever that we can do our jobs at home, where we never would have thought about that before. If the employee, even though they might be entitled under the criteria, right, they're subject to a state isolation or quarantine order, would be technically entitled to leave under this law if they can work from home and if they're capable of working from home, right? If they've developed COVID symptoms and they're really, really sick, they're entitled to it. But if they're not, and they're just sort of waiting it out to see what happens, they're not entitled to the leave and they should be working anyway. Generally speaking, this law, this New York State law, says that if there are greater or richer benefits under another law, then this law doesn't apply. Meaning, right, when we look at FFCRA, to the extent that it is applicable to the business, right, 1 to 499 employees, generally speaking, that's what you want your employee to take. That's what your employee will want to take, especially when you're the small guys who offer only unpaid days. And because it's richer, that's what the New York statute says is the appropriate thing to do, to give somebody leave under the federal statute. Because it's richer, it doesn't name the federal statute, just because the benefits are richer. That's what should be using. Here's a practice tip without an answer right now. This New York State law, remember when I said in the beginning, there's no sunset to it? We're getting close to December 31st, and therefore we are getting close to a new year, January 1st of 2021. Do these days off that the New York law provide renew on January 1st? Do you get another 5 days or 14 days, depending on the size of the business? The law doesn't tell us the answer to that. Interestingly enough, the statute is silent, except that it doesn't expire. What I would say is this: reasonable minds can differ, right? Some folks would say, well, because it's silent, it means it keeps renewing like any other law, except it doesn't say 5 days annually. It just says 5 days or 14, as the case may be. The caveat for employers and those of us who guide employers is we know that our state Department of Labor is very employee friendly. And so be guided accordingly from a risk assessment perspective. It may be that at some point when the Department of Labor puts out more guidance on this particular statute, it will say, oh yeah, of course those days renew every year because COVID's still around. We just don't know the precise answer to that yet, unfortunately. I wish we did, but we don't. So now I'm going to turn from these laws that were designed for COVID specifically to New York paid sick leave law, which is not COVID specific, notwithstanding this gal who's taken her temperature. It is broad and applies to lots of different scenarios. Illness is a big part of it, but there's some others I'm going to talk to you about that are causing an enormous amount of consternation among employers and business groups. It is in many ways a bitter pill for employers to swallow here in New York. understand, under New York State paid sick leave, the big picture is that it pretty much changes everything for every business out there. It does not change things for government agencies or entities. Federal, state, and local governments are not covered by this law. So y'all can go get a cup of coffee if you'd like. But private employers in New York State of all sizes are covered by this. This was kind of shoehorned into the budget bill in April by the New York State legislature. And it is offering now a very new, for many businesses, and in, one might argue, extraordinarily rich benefit that never existed before. So this is sick leave that is paid. And we'll talk about the definition of sick in a second, but I wanted to start with the numbers so I could get them over with because I hate numbers, right? The numbers are this. If your business has 4 or fewer employees and nets $1 million or nets less than $1 million, I want to be really precise about that, $999,999. You have to offer 40 hours of unpaid leave annually. If your business has 4 or fewer employees and nets $1 million plus, those 40 hours must be paid again in the course of a year. If you have a business with 5 to 99 employees, you must offer also 40 hours of paid sick leave annually. And if you're a business, a larger but not giant business with 100 or more employees, you have to offer 56 hours of paid leave. So that's about, in an 8-hour day, 7 days of sick leave, where the smaller businesses are 5 days of sick leave. So the timing of the leave, right? This law became effective September 30th of this year, like 2 months ago, but it's not available to be taken by employees yet. So when I say it became effective September 30th, it meant that that's the date on which hours started to accrue. And this is a kind of an interesting anomaly about this law. Employers can either have the hours accrue, and when they accrue at the rate of 1 hour of sick leave for every 30 hours worked. Whether you're a full-time, part-time, temporary person, 1 hour of sick leave you get every time you churn 30 hours into the books of work. Or you can front load your hours right from the beginning. Even though the hours started to accrue September 30th, as I said, they're not available to be taken by employees until January 1st, the first day of next year. And that's coming up really, really soon. So what are the reasons for this?
Lisa?
Yep.
Can I ask a quick question from the audience? Does the New York paid COVID-19 quarantine leave cover per qualified instance that an employee is issued a quarantine order?
Cover per qualified instance that I don't entirely understand the question, but I think it means like if an employee gets multiple quarantine orders, right? They're really having fun these days. Does it cover every single time? The answer is no. There's a maximum number of days available, and once you use them up, they're gone. I'm seeing another question. If we already provide an extremely generous paid sick leave policy, do you have to worry about all the different COVID sick policies? Do you have to worry about them? No. And good for you for providing a generous sick leave. I would say you might want to think about some of the COVID, particularly the federal FFCRA leave, because you might get tax, withholding tax credits. And that's good for your bottom line. But if your leaves expand beyond, technically you are required to provide that leave if you fall into it. But if you're already giving that much, then I would say it's probably no harm, no foul. I can say that with certainty about this new New York paid sick leave, where the law says if you're already providing an equivalent rich benefit of sick leave, you're okay. You don't have to change things.
Lisa, can I butt in for a second really quick? I'm so sorry. For the COVID, both the New York State COVID leave and the federal leave, is it your understanding that employers can require, hold on, let me back up a minute. Is this 80 hours, let's just call it 80 hours, that employees are entitled to for COVID-related sick reasons? Do they have to use their own accruals, or is that in addition to everything that they have under their collective bargaining agreement or an employer policy?
For the COVID-related 80 hours of sick leave, it is in addition.
Right. So they don't have to use their own sick leave. That stays in the bank.
Correct.
Got
So
it.
if I didn't make that clear, thank you, Kim, for saying that. It's really, really important. It is an additional benefit. So reasons for, again, I know we're talking about, impact of COVID on employment law, but here's the moment where we say, okay, let's set COVID aside, because eventually, as Kim assured us last hour, it is going to end. It will end. We know it will end. Thank you, Kim, for reminding me that it'll end. But New York State paid sick leave will not end. It is here for good, at least, for the foreseeable future. It is huge and expansive, the reasons for this kind of leave, folks. Yes, it applies when somebody is sick. They get time off, and let's assume it's the paid scenario that I talked about. So they get time off for being sick, or their family member who they have to care for is sick. And I can't go into it because I don't have enough time, but the definition of family is enormous too. It's not just, right, your kid and your spouse. It's quite broad. So you have the ability to take time off because of that if you have illness. But also the law's guidance has now made very clear that even routine medical appointments qualify to get paid sick leave. So if I'm going to the dentist every 6 months and I'm an employee who's entitled to a paid day, I get to take it for going for my checkup, my cleaning. I think I get to take some time off that's paid if I'm going to the chiropractor. I have a sort of a snarky comment in my notes, like, what if I've been recommended or gotten a prescription to get massages once a month? Do I get a paid half day for that? I think the argument exists, you might, if it's a prescription. You get time off, employees get time off for mental health reasons, not just physical health, but mental health. And then also for things that the law has generally, or we who are trying to figure out the law, right, because it's brand new, have described as family safety reasons. So if there is a situation in an employee's family where someone is a victim of domestic violence, if somebody has been, a victim of stalking, or God forbid, human trafficking, things like that, and they need to accompany their family member, or they themselves need to go see a lawyer or make plans to enroll their child in a new school district because they've run, or their family member has run from a dangerous situation. All of those qualify to get time off under this new paid sick leave law in New York State that employees are entitled to start taking January 1, 4 weeks and 1 day from now. So let's ask poll question number 4, Maria, if we could. Employees must provide a healthcare provider's note, right? Doctor's note, whatever, nurse's note, to justify sick leave under New York's paid sick leave. Yes or no?
We'll give it a few minutes. I've had a couple people say that the polls haven't launched for them, so we'll give this a few extra seconds here.
While we're waiting, Lisa and Kim, there's a lot of questions coming in fast and furiously now to the chat. Would it be beneficial to wait till the end? Would you mind maybe staying longer, and those who ask questions can stay if they'd like, for you to answer them at the end?
Happy to do that. I'm also trying to respond to some.
Great.
Yeah, and I can, as people are doing the poll, I can answer a couple of them. And we've got a question, can this time be taken in what increments, hours or days? Great question. We're going to get to that in a second. So we'll cover that, I promise you.
I'll end the polling now. The vast majority have voted.
Okay, show us the answer then. Ooh, another 50-50. Okay, so we know in most leave laws, FMLA, paid family leave that we send over to our disability insurance carrier, right? Even COVID sick leave, we as employers are entitled to get documentation, right? Something that shows this person is sick or whatever the circumstances are. Guess what? You can't ask. You can't ask with New York paid sick leave, even though you must give up to 40 hours if you're, under 100 employee business, or even 56 hours if you're a larger business. You cannot ask for documentation. What do you do? That's from the business lawyer perspective and an enormous impediment and challenge to this law. And so a little bit tongue in cheek, but not totally. I say, can you troll your employee? I see Kim gulping. Can you troll your employee? Can you see what they're doing? Because they've taken a paid sick 2 days right before a holiday weekend, for example. What if you have somebody who already has an absentee issue and is a problem child, so to speak, around absenteeism? Can you troll? The answer to that, and again, subject to collective bargaining and any types of provisions that might exist there, and I'm assuming there aren't any. Can you troll? The answer is yeah. Can you look on somebody's social media to see, are they really sick? Or were they hanging out at Sunset Bay with those beers on a hot day we talked about last hour, right? But here's the risk of doing that, and I'm not going to tell you not to do it. What I'm going to tell you is that if you are investigating employees, one, do it discreetly, and two, do it across the board. Just like policies, apply that consistently, not only to particular employees, because if you do it inconsistently and only to some employees, they might, for totally separate reasons, fall into a protected class and later argue once you've terminated them because of their beer on the beach, having taken a paid sick, couple of days, they might say you really terminated them because they're over 40, age discrimination, or because they have a bunch of children and sometimes call in sick because their kids are sick, right? So you have to be careful about being able to justify your application of what you do on a consistent basis. I don't think that that's particularly reassuring, frankly. And I wish I had a magic bullet for New York paid sick leave. I do not. And it gets worse. So let's talk about more bad news. Employee notice, right? Most, I have to believe, Kim, collective bargaining agreements, particularly in school districts, right? Teachers have to give a little bit of notice if they're going to be out sick, right? Because you got to get the substitute in and the lesson plans and all those kinds of things. I'm not the expert like you are at these things, but notice about being out of work is generally part of most employers' policies. Well, paid sick leave tells us there need not be any advance notice. So the employee must tell the employer, but can be up to a minute before their shift starts, which is a real practical concern for employees who don't take their jobs seriously, or don't have the level of commitment and loyalty we would hope all of our employees have. That's the real reality here. So a question, and Kim, I want to put you on the spot for just a second. If a CBA says, like in a school district, says that a teacher must give 12 hours notice, or for whatever it happens to be, prior to being off, do you think that would be a violation of paid sick leave that says you can't mandate some period of time of notice?
Well, I guess it depends. Is the employee using a benefit given to them under the CBA, right? So if it's a CBA benefit in addition to a state law benefit, then I would say that the CBA would apply. I think this would be a really great question for an arbitrator.
It's going to be a great question for an arbitrator, and under non-unionized or non-organized workforces that have that policy in their employee handbook, it's going to be an issue for them. I will tell you that I've had dozens of clients asking me that question since we started talking about and educating our community about this new law. It is a sticky, sticky situation. Kelsey asked a question. Is it 1 hour accrued for every 30 hours worked or 20 hours worked for New York paid sick leave? It's 1 hour for every 30 hours worked, 30. So let's move on to policies, because I want to leave you, and we're getting close to the end, with some more practice pointers. I want you to be able to walk away from this with, right, swallowing the bitter pill of paid sick leave. I'm really sorry about that, but there's nothing I can do about it other than educate you so you can be armed with great information to help make it maybe just a little bit less bitter. But I want to give you practical information that you can implement immediately or think about with your HR resources. We've talked about paid sick leave, right? This new law. We all know about paid family leave that caught us by surprise a couple of years ago. And we all know about FMLA for businesses that have 50 or more employees. You can, through your policies, again, caveat with collective bargaining agreements, if you are a non-organized workforce, you may have a policy that says these leaves must, when it's relevant, run concurrently. So if somebody's taking their paid family leave, they're burning their paid sick leave hours. They maybe even be burning their FMLA hours. So if you have that in writing as a policy, and that's something to consider, right? You have a business to run. You cannot, and here we're going to answer a question from Ms. or Mr. Sorrento. Can this time be taken in what increments, hours or days? You cannot require New York paid sick leave to be taken in an increment of 1 day. You cannot, right? That would make it so much easier for us as employers, wouldn't it? To say for these, 40 hours or 5 days of sick leave, you have to take them in one work day increments. No, you can require, however, a 4-hour increment. So essentially a half day in most 8-hour businesses. So the law allows you to do that 4-hour increments. And of course, if you want to be incredibly benevolent, you can tell your employees they can take it in 1-hour increments, right? How long does it take them to get their teeth cleaned? That would be an HR nightmare as far as I'm concerned, those tiny little slices of increments, but you can do 4-hour increments. And just from a practical perspective, right, as you're writing your new policy, which you should be doing with your lawyer or your HR professional, hopefully they understand this law and are sophisticated, you would want to impose that it must be taken in at least 4-hour increments. Understand, of course. Yep.
Sorry, finish your thought. Go ahead.
That your CBA, if you have a collective bargaining agreement, may say something different. Go ahead, Sarah.
A couple similar questions in the chat that maybe are a quick answer at least.
Oh, sure.
State paid sick leave, does it apply to shift work, and does it apply to all employees, including part-time?
Yes, yes, and yes. It also applies to seasonal employees. And interestingly enough, if a seasonal employee, and let's say it's somebody who, outdoor house painters, right? They can't paint during the winter because it's winter in Buffalo. If they maintain an employment relationship with their employer, they get to carry over their hours. And paid sick leave carryovers. You must allow your employees to carry over unused hours from year to year, but you may prohibit them from using hours more than 40 in any one year. What does that mean? Well, it means that an employee who's with you for a long time, and we love those employees who are loyal and stay with us and educate others who come, after them. What does it mean for them? You want to think about having a policy about what happens with all these accrued hours at the time of separation, whether you are terminated voluntarily or involuntarily. You are allowed to say that those hours evaporate. They do not go with the employee. There's no dollar value to them. They're just available while the employee is with you. So you might ask, well, why would the state have us carry them over if we can stop an employee and make them limit them to taking only 40 hours per year? Well, A good reason for that might be an employee who works full-time in 1 year and then reduces down to part-time. So he or she isn't accruing hours quite as rapidly and might want to use some hours up to 40 in the following year or years. Kristen asked a question, can we allocate the 40 hours of sick time evenly over the year, or must we either front load or calculate an allocation per hours worked? Kristen, you must either front load right at the beginning of the year, and year for you can be anything you deem it to be, although in this first instance, it's going to have to be January 1 of 2021. You can't allocate it and say, you know, Mr. Employee, you may take 1 day every other month, for example, or 4 hours every single month for as many months as they last. You have to let them take the time when they need the time, when they tell you they need the time. And to add insult to injury, you have to keep very good contemporaneous, meaning on the same date records of if people are accruing time, right? How they're accruing it week by week by week with reference to their hours worked, and how they're using it, how many hours have been used. Because if an employee comes to you at any time of the year to say, how many hours do I have in the bank paid sick leave and how many hours have I taken? You have 72 hours, my friends, to give them the answer under the law. Hopefully you all have
Lisa?
payroll services who will provide that information to you quickly. Can you tell I'm a little bit cynical? Go ahead, Sarah.
There was one other question that actually got posted to the chat relative to that net income rule, the $1 million. What happens if you're maybe around $1 million and so that number fluctuates year to year for you?
What a great question. I have no answer for that because we have no guidance on it yet. It's one of those situations, and I'm sorry, right? I'm a lawyer. I'm supposed to have answers. But like Kim told us last hour, some of this stuff is so new, it's all very, very gray. I would say to you, you know, if you're hitting $1 million, you're going to have to provide, right, the paid days. And the next year, if you're not, then they're unpaid days. That's what the law says. But think about it from a morale perspective. We all know as employers, once we give a benefit, goodness gracious, we better not take it away, right? From a morale perspective, it's probably not a particularly pleasant answer that I've just given you. Thank you for that question. It's a really, really good one. We just don't have clear guidance from New York State. They gave us some, like after the law became effective, September 30th, it took them another 10 days or so to get some guidance out there by way of just, you know, loading questions and answers, FAQs on their website. We still don't have regulations for this particular law. That's how state agencies are supposed to give us guidance, is through regulations, or where we, the citizens of the state, constituents, have an opportunity to provide comment. We're still waiting for regulations. We don't know if or when they're coming. Here's a question. Is an employee allowed to carry a maximum of 40 hours into the next year? The answer is yes. Can they carry 40 hours every year so that at the end of year 2, they would have 80 hours? Answer, yes. But in year 2, or even in year 3, you can still limit them to using only 40 hours. And as over time, they continue to accrue those hours, and they might think, ooh, I'm holding it for some later great thing, or when I retire, I'll cash them out. No offense to Kim and collective bargaining agreements, you can make it a policy that there is no cash value to paid sick leave hours, and that people are not entitled to take them with them when they separate from employment.
But if your CBA says otherwise, I would argue.
Unless your collective bargaining agreement says otherwise. Yep, thank you, Kim. You're absolutely right about that. Super important, folks, to be talking to your payroll companies now. It's even maybe a little late. We've been helping our employer clients talk to their payroll companies and redesign their leave policies. Again, those employers that don't have a collective bargaining agreement, our clients that do, taking a different tact with them. We've been talking with their payroll services and them since probably July and August to prepare for this, because this is a big deal. General policy considerations as we wind down this session. Clarity, of course, you want to be thinking of policies that apply in this COVID world, but otherwise as well. Work from home policies. We want sick leave policies, right? That now have to be reoriented. You have to think about, if you have a general PTO policy, are you going to have a separate bucket for sick leave, or is sick leave going to be part of it? And how's that going to work? You have to think all these things through. You need to have, if people are working from home or even in the office, technology policies, right? Confidentiality if they're working remotely. Sexual harassment, right? That was the big deal a couple of years ago when the state said every employer in New York State must have sexual harassment prevention training. The state did not relent on that in our COVID era. So you still have to have your employees trained in sexual harassment prevention every single year, including this year, which has been, right, an upset and a sort of a hellacious year to be an employer. And as Kim said last hour, to be a boss. This has been a hard year for all of us. Think about a policy for BYO devices, whether you're bringing your own device to the office or the workplace, or whether you're using your own devices when I say your, I mean your employees at home or wherever they're working remotely. These policies, you should have them in writing. They should be in normal, common English. Don't let some lawyer talk you into a bunch of wherefores and crazy words that people don't understand. They should be in common English that everyone understands. You should insist that your employees sign off on receiving these policies so that you have documentation if you later need to consider discipline or other situations given somebody's violation of a policy. And you need to apply them consistently. So everybody has a policy applying to them in the same way. So you don't fall prey to somebody who claims you were applying a policy to them unfairly just because they are a minority, or just because they are a woman, or just because they are over the age of 40. So you want to apply these policies consistently. Here's my last slide. Feel free to reach out. Of course, we are not your lawyers unless we are your lawyers, and we might be for some of you. But we're generally blogging about these employment matters all the time at our website and in our social media at the Coppola firm. We do have an online sexual harassment training module at sexual-harassment-prevention.com, soon to be coppolatrainings.com, if you need that. So I'm delighted that Sarah and your colleagues, thank you for asking us to be with you. Kim, it's been a joy to do this with you, and good luck, everybody. Employment law is a crazy complicated area.
Thank you both so much. There is one final question, and it goes back to the 4-employee $1 million thresholds. Is that 4 versus 5 person based on an FTE or a head count? Do you know that?
Carol, it's head count. I'm sorry, it's head count.
Probably not the answer they were hoping.
No, it's not the answer you want.
Yeah.
I understand.
So Thank you again both so much. These were extremely helpful sessions. Yes, the sessions are recorded. Yes, the recordings, and both speakers have agreed to share their slides as well. So the recordings and the slides will be available on our website, lumsdencpa.com, probably on Monday, if you'd like to check then. And this concludes our conference for today, but we have another 3.5 hours tomorrow, starting again at 9 a.m. You should be receiving an email that comes from Lumsden McCormick with your links. I believe Maria also sent one out again this morning directly from her, Maria Gambacorta. In case the Lumsden one wasn't working. The pop-up, please answer the pop-up questions that come up at the end of this. CPE credit, as Maria mentioned, will be provided by December 21st. Thank you both so much again. And Maria, am I missing anything?
Just one quick clarification. We will not be sending a follow-up email for all of the sessions tomorrow. You received it today, I think 3 times. And I just put it in the chat as well. So I think everyone is covered with email. So hopefully we'll see everyone tomorrow morning at 9.
Great. Thank you very much. Thanks.
Thanks, everyone.